Hello folks, I'm Bebopo Lula, and today we're diving into one of the big ones, dismissal. No, this is not about when your mate gets red-carded for kicking the goalie in the bollocks. We're talking about being let go from your job. Get the boot. Axed. Sacked. By the end, you'll know exactly what counts as a dismissal under Irish law in terms of the Unfair Dismissals Act 1977 and why that definition is so important. Although not essential, you are advised to watch the video on types of dismissal as this will give you valuable insight into the statutory definition. Right, let's start simply. The Unfair Dismissals Act of 1977 tells us when an employee is considered to have been dismissed. Note that the same section defines an employee as someone who has entered into or works under a contract of employment. Remember also that a contract of employment is sometimes called a contract of service. This is distinguished from a contract for services, which usually points to someone who is self-employed and therefore, by definition, cannot be dismissed. But I'm rambling like an idiot. Back to the matter at hand. In Section 1 of the Act you will find the definition of dismissal, which is broken down into 3 separate paragraphs. Essentially, this means there are 3 main ways a dismissal can happen. Let's break them down into plain English. For the dismissal contemplated in paragraph A, the defining feature here is that it is the employer that brings the contract of employment to an end. You will remember that when we looked at the common law types of dismissal, this pretty well covered all the dismissals, apart from one where the employee terminates the contract. Therefore, this paragraph covers many different types of dismissal: wrongful, lawful, summary, and perhaps types of dismissal that haven't been invented yet. As long as it is the employer who unilaterally ends the contract, it should be covered by paragraph A. Under paragraph B, the defining feature is that it is the employee that unilaterally brings the employment to an end. On the face of it, that is usually called a resignation. However, where the employer's conduct has made it intolerable for the employee to continue working for that employer, it becomes something different. Maybe they made your job intolerable, cutting your hours, shouting at you or assaulting you, or even moving you to a role you were never trained for, and that is totally different from what you signed up for. A resignation is where the employee voluntarily ends the contract to take up a better job, for example. A forced resignation, on the other hand, is not regarded as a resignation at all. Remember what it is called? That's right, a constructive dismissal. If any reasonable person would say, "I can't work under these conditions," then resigning can still count as being dismissed. The law says if it was reasonable for you to leave because of your employer's behavior, it still counts as a dismissal. This can be a series of incidents that finally make you crack and you storm out, or it could be one particularly serious incident that would be seen to destroy or irreparably damage the employment relationship. When the law uses the word constructive, it usually means we will treat it as being. In other words, this would usually be a resignation, but in these particular circumstances we will treat it as a dismissal. A constructive dismissal. Paragraph C is essentially an invention of the Unfair Dismissals Act. This situation was never contemplated by the common law and is really an extension of the legal concept, a legitimate expectation. This happens when your fixed-term or specific-purpose contract runs out and it's not renewed. Now, this is when you have to think carefully. When a contract expires naturally, it can never be a dismissal. That has always been the law and that has not changed. When a fixed-term contract has run its course, it expires, poof, and it's gone. What is different here in paragraph C is that you reasonably believed that the expired contract would be replaced with another one. This is often called a legitimate expectation. Let's say you're hired for 3 months at a time, and this is simply repeated again and again, the series of 3-month fixed-term contracts. This becomes an established practice until you don't even think about it anymore. You just turn up for work 3 months at a time. These are often called rollover contracts or back-to-back contracts. Then one day you report for work and suddenly, Out of the blue, the employer says sorry, no work. You can argue that because nothing had happened or was said to make you aware that the present contract would be the last, you had a reasonable belief or a legitimate expectation that things would continue as before. The failure of the employer to provide you with another 3 months of work is a dismissal. But if your written contract clearly says that the Unfair Dismissals Act won't apply when the fixed-term contract ends, and both sides signed that, the Act won't protect you in that case. So read that contract carefully before you sign. Finally, please note that this definition only defines what a dismissal is. It does not define whether that dismissal is fair or unfair. That discussion is for another day. So adios all, until next time, I'll just bebop out of here.